Let's bring in Kim Wehle. She is a professor of law at the University of Baltimore and author of What You Need to Know About Voting and Why. Kim, really good to see you again. Thanks for being with us. What are the central questions the Supreme Court is considering over the Affordable Care Act?
So this is the second time, as Jan said, that there's been a lawsuit challenging it. The first time, essentially, the court said the individual mandate is constitutional as a tax. Congress in 2017 then went and basically said, okay, we're going to make the tax $0. Then is it a tax anymore if it's not actually getting any revenue into the federal government? That's the lawsuit now. The second lawsuit saying, okay, Congress changed the law, made the tax zero. It's no longer constitutional because it's no longer a tax. But the issue that the justices are dealing with, two things primarily. One is whether the plaintiffs, the state of Texas, for example, are even injured by that at this point. The law is functioning, and they made pretty strained arguments to say that they were injured. Without an injury, you can't be in court. The second is essentially, even if you just say, okay, the individual mandate is now struck down because it's not legitimately a tax anymore, does the entire act have to fail? And that's what we heard with Justice Kavanaugh and Chief Justice Roberts when they were saying, well, Congress amended the statute in 2017 to make the tax or the penalty zero. And at that point, they could have struck down the entire law, and they didn't. So why should we do it now when they didn't even do it when this whole thing was before Congress?
So what exactly is different now that could potentially lead to a different outcome? Obviously, we have a different composition on the high court now.
Yeah, so I think it's really telling, frankly, that two justices, Kavanaugh and Chief Justice Roberts, went on the record to say, we think the Affordable Care Act is going to stand. Because even if they strike down the individual mandate, that's not going to make a huge change for people. I think they wanted to send a message, and Justice Kavanaugh in particular is pretty stunning, actually, as a conservative Trump appointee. Chief Justice Roberts is now the swing vote with Justice Kennedy gone. Justice Kavanaugh is coming out and saying, listen, I'm not touching this one. This is for Congress, and it seems really clear what the language of the statute is. I'm not going to do much with it. So, what's different about it this time is that we've seen, I think, some years now of the Affordable Care Act actually functioning, more years than the first time it came up. And so the justices, it's hard to come up and say, before these justices and say, this Affordable Care Act is hurting us so much, this individual mandate is hurting us so much, when effectively it hasn't really been functioning since 2017. The justices are basically saying this is so technical, we're not going to mess it up. At least that's the expectation, according to Jan's reporting and my listening of the transcripts as well.
I'm just wondering, Kim, what your take is. You mentioned Justice Kavanaugh, but you had two of the court's conservative justices, Chief Justice Roberts and Justice Kavanaugh, appearing to hint that they would be open to striking down, part of the law while keeping the majority of it intact. Is that an outcome you would have necessarily predicted, considering how contentious we saw in Justice Kavanaugh's case, the confirmation process unfold, as well as even with Amy Coney Barrett, there being questions about what that strengthened conservative majority on the high court might actually do with the ACA?
Yeah, so, I worked with Justice Kavanaugh back in Ken Starr's office in the Whitewater investigation. He's a very, very smart jurist, one of the smartest lawyers I've ever met, frankly. And so it doesn't surprise me that he's going to not take a political point of view when it comes to something like this. He's going to say, listen, our job is to apply the law. Now, footnote on that one, this was a huge deal in the Amy Coney Barrett proceedings. She testified that judges just apply the plain language. And this is not to suggest that the ACA, this case wasn't hard, because it is a hard case. All judges actually have to judge. All judges deal with ambiguous language. So when people like Amy Coney Barrett suggest that they don't actually do that, that's just false. And I say that because there will be many other cases that come before this court where the judgment of the judge is going to make a difference as to whether language is construed one way or another. And we can expect Amy Coney Barrett to have a more conservative point of view, maybe a point of view that traditionally has favored more corporate America than individual people, like, for example, seeking Bill of Rights protections, with maybe the exception of the Second Amendment. That's what judges do. It's just nothing special about her that she's not going to do that. What we saw today, I think, in this argument, is the fact, for the most part, judges call balls and strikes based on the facts and based on the law. We're seeing this with the lawsuits going, challenging the election results. No fraud, no evidence of fraud that's meaningful, that's surfaced. The courts are just saying, listen, we can't help the Trump campaign. That's one of the beauties, frankly, of the court system. Federal judges are there for life, so they don't have to worry about being reelected. They don't have to worry about bad decisions making them basically get fired. And they're bound by rules. They're bound by the rules of evidence, and they're bound by, in this case, the rules of civil procedure. Unlike politicians, unlike Twitter accounts, they can't just go really far any direction unless they have law and facts to back them up.
All right, Professor Kim Wehle. Kim, always so insightful to have your expertise. Thank you so much.
Thank you, Elaine.